Hello and welcome. My name is Andrew Rossner, and today I'd like to discuss employment discrimination. It's important to understand the definition of what discrimination is versus prejudice and how it impacts employees in the federal government and private sector workplace. So today I'd like to cover the definitions of prejudice, of discrimination, and how it impacts the government and how the government is dealing with those kind of issues in the private workplace. I'd also like to talk about the history of the laws enacted to help prevent discrimination. Also talk about some covert activities that employers use to sort of muscle a person out of a position if they feel like they don't want them there anymore for whatever reason, especially discrimination, and the evolution of the law. Where is it going? What new groups might be protected in the future? Discrimination in and of itself is not a bad thing. We do it every day. Oftentimes we choose an apple over an orange, or we choose to take our vacation in Florida or California. So unless discrimination hurts an individual or causes harm, in and of itself is not a bad thing. Prejudice, which is a form of discrimination, is definitely harmful to individuals. When an employer makes a decision to hire, fire, lay off, promote, demote somebody based solely on their race, their religion, their national origin, or their gender, then we're dealing with discrimination that harms somebody. Congress originally started enacting laws to prevent discrimination in the workplace. The Constitution in Title 5 and 14 basically protects federal employees against discrimination, but until the 60s there was no private sector discrimination laws protecting those in the private sector. So in 1963 a law was passed to prevent inequities in pay between men and women. It was the Equal Pay Act, and it basically said if you're performing the same job, whether you're male or female, you should get the same pay. Now, one of the things we probably all are aware of is back in the 60s, very few women held the same position as men. Certainly, there was no women in the C-suite of most major corporations. So, despite the Equal Pay Law, it really didn't affect or correct this inequity because people weren't in the same jobs. Even today, it's commonly known that 80% women get paid 80 cents on the dollar for equal positions that they serve in as men. So there's still work to be done there. Title 7 of the Civil Rights Act of 1964 probably had the greatest impact on the private sector. It basically said that an employer could not discriminate against an individual based on race, religion, national origin, or sex, color as well. And so this law basically said that employers needed to avoid those areas in their decision making. The law also basically said that if there's need for accommodation, that particular company would have to provide accommodation if it was not an undue hardship to them. And we'll see later on that that comes up and is a more relevant item in the Disability Act. The Age Discrimination in Employment Act of 1967 basically said that an employer could not discriminate against an employee based on age, specifically those 40 and older. Section 501 and 505 of the Rehabilitation Act said that the law made it illegal to basically discriminate against somebody based on a disability in the federal government. Again, accommodations were necessitated to help that individual perform that job if they were not posing an undue hardship on the employer. The Pregnancy Discrimination Act of 1976 basically said that an employer cannot discriminate against a woman based on pregnancy, childbirth, or medical condition relating to that pregnancy or childbirth. Title I of the Americans with Disability Act in 1990 said that employers cannot discriminate against an individual with a disability. For example, in the private sector, any kind of physical or even mental disability or mental health condition could not be discriminated against. So this basically said that, if an accommodation was needed, perhaps a handicap ramp or somebody that could interpret for a hearing impaired individual with sign language, those were conditions that the employer needed to meet to accommodate that individual. Sections 102 and 103 of the Civil Rights Act of 1991 increased pressure on employers in that if an employee was found to be discriminated against for disability, that a lawsuit could be brought against that employer, and a jury could award not only monetary compensation but also punitive awards against that employer. So this really made the law much more serious and gave employers a real motivation to abide by that law. The Genetic Information Act 2008 was a further evolution of the law, and basically said with advancements in genetic screening, an employer cannot discriminate against an employee, for example, if they had a propensity for a heart attack or had a history of cancer in their family, so the employer could not take that into account when making an employment decision. All of the above-mentioned laws protect individuals against retaliation if they participate in an investigation of discrimination or file a suit against the employer or file a claim with the Equal Employment Opportunity Commission. Many employers use their influence and their power to basically encourage employees to leave if they don't want them employed there anymore. For an example, assigning them to very unpleasant jobs, relocating them to a poor area of the country, basically having their superiors or their subordinates promoted, and then even sometimes having to report to those subordinates even though they are more qualified for the position. So there's a lot of things employers can do covertly to encourage an employee to leave if they don't want them employed anymore, and those are the things that are very difficult to prove in the court of law when we're talking about discrimination. Some of the evolution of the law includes the transgender group being included in the sex or gender portion of Title VII of the Civil Rights Act. So they are protected under their gender, whether it be male, female, or change from male to female or vice versa. Bisexual, gay, and lesbian groups are not covered currently, but litigation is showing that it's becoming an increasing area of focus and concern. And very shortly, I would believe that those particular groups would be included under the sex or gender area, just like transgender individuals. Some areas of discrimination that occur every day that are not covered by law and perhaps would be difficult to determine or prove. Many of us have heard that there have been studies of interviews, and individuals that are attractive have received jobs at a disproportionate level to those that are not. Obesity is something that is a physical condition but is not protected, and oftentimes employers overlook individuals because of their physical appearance or their weight, concerns with medical claims or their ability to perform the job. If a person has committed a felony and they're rehabilitated, oftentimes they have a very difficult time getting a position because of their criminal record, even though it might not have been a violent offense. And finally, a lot of employers do background checks, and it is a very hot topic in Washington as to whether credit checks are discrimination against an employee. Basically, credit checks poor credit not being a factor in the job that they have to perform, but they are overlooked based on a poor credit history. So the question is, can these areas be governed? Can these areas be included in the protection laws? And if so, how would they be enforced? So with that, I'll close, and I thank you for your time, and that's the end of my presentation.